Thanks very much, Lascan Corla, and I welcome the opportunity to contribute to the debate today on this very important legislation. This bill does come before the House after years and years of inaction and no activity taking place on it, and I do commend the government for bringing the bill forward to at least getting to the stage where those years of inaction can be put to an end. And I will be supporting the bill, although I do believe that in a number of cases which I'll outline, that the bill doesn't go far enough. And I also believe that there are some penalties included in it which shouldn't be there at all. And I think it is true, as has been said by other speakers, that the Irish people are actually way ahead of the politicians in relation to this issue and to the issue of terminations and pregnancies. And the Irish people are showing a lot more compassion and understanding of the difficult situations that many women find themselves in relation to this issue. And the issue of terminating a woman's pregnancy to save her life, even her physical and mental well-being, is much less of a controversial issue by the majority outside this House than inside. And this goes back a much longer time than people care to realise, I believe. While the 1983 referendum, which established the Eighth Amendment, asserting that the unborn had an explicit right to life from the time of conception, subsequent referenda strongly suggest that public opinion began to focus on the rights of the mother. In the immediate aftermath of the X case, the government put three referenda to the Irish people: the 12th, 13th and 14th proposed amendments to the Constitution. The 12th Amendment asked to remove suicide as a grounds for abortion. The 13th Amendment asked that women should have the right to travel outside the state for abortions. And the 14th Amendment asked that information about abortion should be available within this state. If Ireland is as opposed to abortion outright as is suggested by some, you would expect that the 12th Amendment would have passed and the 13th and 14th would have failed. But as we all know, the opposite is actually true. In a majority of 2-1, Irish people voted to reject the 12th Amendment, thereby endorsing the Supreme Court's decision on X. They also voted to allow women the right to travel for abortion and their right to information about abortion to be made available in Ireland. In doing this, a majority of the Irish people demonstrated their support for terminations and abortions in line with the X case. A decade after the original case, the then Taoiseach Bertie Ahern held another referendum, effectively asking the same question as in the failed referendum in 1992 regarding suicide. And the Irish people gave the same answer: no. Now we're here in 2013, where this issue has again become the topic du jour, where despite the controversy, opinion polls show a clear majority for support on legislating for the X case, including the so-called suicide clause. And there are even polls that show a majority in favour of terminations in cases of fatal fetal abnormalities, incest, rape, and when a woman's health is at risk. By continuing to ban abortion, we do not prevent it. We just export it, disguise it and deny it, instead of addressing these women's genuine needs, not all of which are included in this bill, and those that are, I am sceptical of their accessibility. But I do recognise that this bill is a step forward. While I understand that abortion for instances of rape and incest would need to go before the people, I believe that there is scope to legislate for abortion with regard to fatal fetal abnormalities in this bill without it infringing on the Constitution. It is possible to interpret Article 43(3) so that the unborn that is protected therein does not include those fetuses with fatal abnormalities. The Irish courts have not considered this legal issue, and there is no binding precedent excluding such an interpretation. Moreover, the legislature has the power and the duty to legislate under the Constitution. When Justice McCarthy criticised the legislature for failing to regulate the terms of Article 43(3) in the X case in 1992, he was speaking of a duty that existed prior to that case. The interpretation and regulation of Article 43(3) is not limited to the circumstances which arose in X. And that case showed how the general principle of vindicating unborn life with due regard to the equal right to life of the mother justified a termination in the particular circumstances of suicide risk. A different set of factual circumstances, such as those of fatal fetal abnormality, could also legally justify a termination of pregnancy, given that these unborns will not live independently outside the womb. Therefore, I believe it is within the legislature's power to act on this possibility and regulate for these circumstances, and in such instances, the legislature has a moral as well as a legal duty to act now and include terminations for fatal fetal abnormalities within this bill. Indeed, the government argued in the European Court of Human Rights that in this particular case, that if the woman had gone before the Irish courts, that there was a very strong possibility that the courts would have ruled in her favour. So therefore, the question of constitutionality doesn't come up. I would also like to take this opportunity to address some arguments and misconceptions in relation to this bill, which I think it is important to clarify. There has been much talk to the effect that no time limit in the bill will result in late-term abortions. But this is not an accurate assumption. However, the omission of a time frame for termination of pregnancy is a necessary element in instances of a woman's life being at risk late in pregnancy. If there was a time frame, legally she would be left to die. And in that instance, both the mother and fetus would die, thereby actually contravening the protection of life. Whether as a result of the risk of life by physical illness or suicidal ideation, where the fetus could live independently, the pregnancy would be terminated by being induced, not by being aborted. This aspect in particular is causing a lot of confusion outside this House. There is also, unfortunately, an opinion spouted by some that women will fake suicidal ideation. I believe this is a very flawed argument. While everyone speaks of removing the taboo from mental health issues, we have this debate where people are suggesting that women would go so far as to lie to a 3-member panel of medical practitioners just because she feels like having an abortion. If a woman truly feels that way, she would get on the boat to the UK. In fact, this scenario is so restricted in the bill that someone who is suicidal would probably travel to the UK anyway, rather than go through the onerous procedures in this legislation. But overall, I believe this argument is further stigmatising the sensitive issue of mental health and is most unwelcome to the debate. And let's not forget, this bill isn't actually changing the law on abortion. It's legislating for something that has been deemed legal since 1992 by conservative middle-aged men in the Supreme Court. And it's a far cry from the abortion on demand and the inaccurate perception that the same thing that happened in the UK will happen here too. If anyone would care to read the British legislation, which was enacted in 1967, they would realise that a referendum would be needed to have legislation even remotely similar to their Abortion Act. And with this bill and the Irish Constitution as it currently stands, there is absolutely no possibility of that same thing happening here. I have some concerns about the actual bill itself. Regarding conscientious objection, I believe that this is allowing for a personal opinion to interfere with a professional duty. I understand that not all relevant medical practitioners would be comfortable with carrying out these procedures, but if that's part of their job, I can see this as being problematic in the longer term, if and when they're required to do so in such matters. What if there's an emergency situation and there's no one else to carry out the procedure at that point in time? I believe the bill should include a very strong clause and sections in relation to a duty of care to ensure that in these situations that the medical practitioner with the conscientious objection has a duty of care to that patient to ensure that she is passed on to the care of someone who doesn't share that conscientious objection. I also have concerns regarding the powers that the Minister would have, particularly in relation to the power to suspend the service where there is an ongoing investigation.
2 minutes remaining.
Thanks. While I appreciate the need to ensure that the legislation isn't exploited by any person or institution, it's also important that no minister exploits this legislation, and that such a suspension is only carried out when completely necessary and is revoked as soon as possible to avoid a situation where a loss of life occurs during this time because of this suspension. With that in mind, it's also vital that any such procedure is carried out without undue delay, and that in cases of risk to life from physical illness, any such risk need to be immediate or inevitable to ensure that this risk of life from physical illness does not become an emergency situation. And I believe that the certification under this should include a time frame for the termination to take place to ensure that this delay does not become an emergency. Last but by no means least, Section 22 of the bill states that to intentionally destroy unborn human life is an offence for which a woman is liable to imprisonment for a term not exceeding 14 years. If the bill is not amended in this regard, there is a situation for a woman who wants an abortion for any reason other than the avoidance of an immediate threat to her life. It will be perfectly lawful for her to travel outside the state and have an abortion for medical or social reasons. It will be perfectly lawful for clinics outside the state to give that woman all the information she needs on how and where to have that abortion. But if she has the abortion on this side of the Irish Sea, she is liable to be sent to prison for up to 14 years. The crime that merits this sentence is not having the abortion, as has been in this House already. It is having it in the wrong place. There are serious implications to this. The state, through the HSE, currently supports and provides post-abortion medical service across the country. These services include free, non-judgmental follow-up treatment for women who have had abortions. What if, for example, a woman who orders an abortion pill online experiences complications and seeks medical treatment or is rushed to hospital hemorrhaging, and she happens to say that she took the pill here? Under the proposed legislation, surely these hospitals cannot be non-judgmental about what the Oireachtas will have defined as an appalling crime. Yet she could be imprisoned for up to 14 years, and I believe that that is fundamentally wrong.
Thanks, Deputy.
An estimated, in conclusion, an estimated 4,200 women travel from the Republic to Britain and other European countries each year to end a pregnancy, and in most instances this bill is continuing this trend. I do believe that more can be achieved in this bill. However, I do recognise its importance, and I therefore will be supporting it.